we need a lot of strategy because there is a war on doctors. And those in the room who've been practicing for a long time know this. The younger medical students, there are a lot of enemies of doctors out there. There are a lot of enemies of the medical license. Medical license is probably the most valuable license anybody can have, maybe in the world. And there are a lot of people who don't have that license who are jealous, who want to make money off of it, who want part of the action. We've got government, we've got hospitals, insurance companies, and these recertification groups. They all want a piece of the pie. And the problem is that in doing so, they interfere with the ability of the physicians in this room and elsewhere to see patients. They take away your time. And time is something that nobody in this room has an excess of. Time is the scarcest metric for a doctor. The average time that a doctor can spend with a patient is only 7 minutes. It's all you have on average to spend with a patient for most doctors. Half the counties in the United States don't have a single OBGYN physician to see women. In Massachusetts, you have to wait many weeks or months to see a primary care physician. There's a big shortage of doctors. Access is a much bigger problem for the American public than quality of care. And this is something that all these groups that interfere with doctors, government, insurance companies, hospitals, and recertifying groups, they don't pay any attention to that. That they're making the shortage worse, basically, is what they're doing. And so when I deposed the executive director of the Texas Medical Board in our litigation against that board, which is still ongoing, I'll give you an update in a second. One of the first questions I asked her, this is a medical board that is constantly harassing doctors in Texas. They are the worst medical board in the country. Repeatedly, on the backs of doctors, they process complaints at a much higher rate than any other state. And I asked her, straight up, simple question, is there a shortage of doctors in Texas? And she didn't know the answer. She couldn't speak with confidence as to what the answer to the question is. The answer to the question is yes, there's a huge shortage of doctors in Texas. There's a huge shortage in most of the areas of this country. And yet we allow these groups to interfere and to take time of doctors away from practicing medicine. And sometimes they revoke doctors' licenses. Sometimes doctors are sent to jail unjustly. We heard from one member who had been served time in jail for a crime he never did, for allegations that were made up against him by a bunch of patients who were drug addicts and were looking for a plea bargain in order to curry favor with the prosecutor. So they made up a story about the doctor saying he was giving them drugs for sex. It was told to the jury. The jury didn't know what to believe, but couldn't believe that someone would make that up and it would go as far as a trial. Well, one of the women admitted after the trial she did make it up. She admitted she made it up, and he still was not released from jail. The government continued insisting that he remain in jail. Well, he wrote an article for our journal talking about his new understanding of our criminal justice system, where someone can go to jail for something that they never did. And even if you prove that the testimony was false at trial, they will not give you a new trial. These are all threats to the practice of medicine, and they're constantly out there. It's constant pressure. It's what makes being a doctor a stressful occupation. We sued the Texas Medical Board to get them to back off in how they were harassing doctors in Texas. And the Federation of State Medical Boards is located in Texas. We thought that'd be a good state to set an example. We went up to the Court of Appeals. We got a good precedent set by the U.S. Court of Appeals for the Fifth Circuit, whereby AAPS as an organization has standing to sue on behalf of our members against other entities that are interfering with the practice of medicine. So we established that legal precedent where, as an organization, we can bring these lawsuits on behalf of our members against other entities who were interfering with our members' ability to practice medicine. And the case then proceeded. We set another tremendous precedent in that case where we got a federal judge to order the Texas Medical Board to uncover and disclose complaints against doctors that they insisted were to be forever kept confidential. In Texas, as in some other states, people are allowed to file complaints confidentially against doctors, and the doctor is never able to learn the identity of his accuser. And the Texas Medical Board was hiding behind that shroud of confidentiality, where what was really going on was a lot of bad faith complaints. And we got a federal judge, he agreed with us, and he ordered the Texas Medical Board to turn over those complaints so that doctors could then see in the particular cases we were talking about who was filing those complaints. So that's a good precedent to keep in mind. If you get hit with confidential complaints against your practice, we can go into federal court and we can get that veil of confidentiality lifted and find out who was filing those complaints. We put the Texas Medical Board on trial late last year, precedent setting to have a full trial against against any medical board, any state medical board. And they had to answer our questions on cross-examination. I put them on the witness stand. And in front of the judge in an open court, we had the trial, then we had closing arguments in February, and we're still awaiting a decision by the federal judge. It's a bench trial, so the judge renders the decision. We've asked for declaratory relief, declaring that what the board has been doing is unconstitutional. It's violating the Equal Protection Clause of the Constitution by treating some doctors in an unjust way, violates due process by not giving doctors due process, and violates the First Amendment rights of doctors by retaliating against doctors who speak out. Or in one case, a doctor who got an injunction against a patient who kept filing, not a patient, a nurse who kept filing complaints against him. He went into state court, got an injunction against her, and then the medical board retaliated against him for exercising his First Amendment rights to go into court to enjoin a serial complainant. So that's part of our case too, and we want the federal judge to declare that to be unconstitutional the way the state medical board retaliated against this doctor and has retaliated against other doctors. So we continue to await word on that, but our lawsuit has been very beneficial. And the state medical board and all state medical boards now know that there is accountability for their wrongdoing. And if they're going to, thank you. They're no longer able to just abuse their power however they like without having to answer for it in federal court. So that precedent is set regardless of what the federal judge rules, but we're hoping for a good ruling as well, and that may go up on appeal again, and we'll continue to prosecute that case, AAPS versus Texas Medical Board. And this is why AAPS exists. We're a membership-supported organization. We don't take money from corporations. We don't take it for selling coding manuals. We're by members, for members. We'll have our board meeting tomorrow. You all are welcome to attend if you like, and we plan our strategy to help physicians and patients. Our motto is all for the patients. So let me move to the second lawsuit that we've got pending, which relates to this recertification racket that's going on, this money-making scheme that you've been hearing this afternoon. And what happens is when there's no check and balance, when there's no accountability, when there's no transparency, these groups, in this case the specialty boards, find ways to make more and more money off of doctors. And the way they do with this recertification is not just that they're imposing these burdens on doctors to pay them fees, but there are huge time requirements too. Some of these recertifications can take hundreds of hours for doctors to do, and they still may not pass because they're being asked questions, as Ken Chrisman said, they're being asked questions like, what angle is the x-ray machine pointed at? When someone takes an x-ray that the doctor doesn't even do. That's done by a technician. Well, if you answer that question incorrectly, then you may not pass the exam. And so after you put in 100 hours to recertify, you may get a failing grade, as 10 to 20% of physicians do when they go through this recertification process. And then where are you? Then you're stuck. Then you have to go through it again, pay new fees and stuff, take more time away from your practice. These are patients who are then not able to see you during this. Well, what are the consequences? If it were truly voluntary, the reality is nobody would do it because everyone knows that this recertification is just a racket. So these specialty boards have figured out a way to make it so it's not really voluntary. And they have pushed their recertification into hospitals such that if physicians do not recertify, then they're kicked off the staff of a hospital. And this has happened in New Jersey. And we identify the physician by his initials in the complaint because we know they've got a smear machine on the other side and they've already lashed out at several people who have dared to challenge their money-making scheme. And when somebody stands between people who are making $800,000 a year and someone stands between that person and that gravy train, that person's going to get nasty. And they're going to lash out at the people who are upsetting their gravy train. So we are identifying this physician by his initials for now, J.E., and what happened to J.E. was he's an exemplary physician in his community, well-liked by everybody, decades of experience. He was board certified once, but he did not recertify. And the hospital said, you have not recertified, so we're kicking you off the staff. So he has been kicked off the staff of a hospital in New Jersey for the simple reason that he did not recertify. That denies his patients the ability to see him at the hospital. And this is another area of medical practice that the public is just starting to wake up to. And even politicians are not fully aware of it, although it was interesting how the fellow who was here earlier today, Andy Thompson, I think was his name, he talked about how the hospital industry has gotten aggressive and it's starting to dictate legislation. A hospital industry is getting very powerful, and he's aware of it. Most politicians are not, but if you listen closely to his talk at the beginning of our seminar, he was hinting, and he chose his words carefully, but the hospital industry is becoming a big problem. And what most people don't realize, most members of the public, is that when you have a car accident and you're taken to a hospital by an ambulance, hospital that they take you to, first of all, it's probably decided by a secret agreement between the ambulance companies and the hospitals. And there may be money that's going back and forth as to which hospitals those ambulances take the patients to. And you end up in a hospital, the first thing you're going to want is to have your primary care doctor see you there. And he's not going to be able to see you there because hospitals are rapidly controlling which physicians they will allow on their staff so that they can control the decision-making that is made at that hospital because that affects their funding. And they're able to maximize the money they make by controlling and limiting the doctors who are on their staff. So in the case of J.E., he's been kicked off this hospital staff now. Well, he has thousands of patients in the area. When those patients end up in that particular hospital, they're going to be surprised and shocked that J.E. cannot see them in that hospital. J.E.'s got a license to practice by the state of New Jersey. He's in good standing. He's, as I said, he's a first-class physician, and yet he cannot see his own patients at that hospital. The patients cannot request to be seen by their own doctor at this publicly funded general hospital. And there's something wrong with that. And what's wrong with that in legal terms? I mean, there's a lot of things that just, that shouldn't sit right with anybody, that patients are denied care by their own physician at these publicly funded hospitals. In legal terms, what this is it's restraint of trade. And that is what we have put in our complaint against the American Board of Medical Specialties. That the American Board of Medical Specialties, which is the umbrella group for 24 specialty groups that are pushing this recertification, what they are really doing is they are restraining trade and limiting the output of physicians, the amount of services physicians can provide to patients in order to sell their recertification product. And restraint of trade is a violation of the Sherman Act. The official name is the Sherman Act of 1890. Actually, it was proposed by John Sherman from right here in Ohio. So some of you who know Ohio history are familiar with that. It was one of the most successful pieces of legislation in the entire history of the United States. And that prohibits restraint of trade. And ABMS, along with these 24 other specialty groups, and of course there's the AOA is doing it for osteopaths as well. They are restraining trade. They are limiting the output of physician services. They are, they've entered into agreements and they are promoting a product that limits, reduces the ability of physicians to see patients. JE can no longer see his many patients at this hospital because of the recertification program that is being pushed by the ABMS. And that is in legal terms, that is the violation of federal law that AAPS has now sued ABMS with this claim. Restraint of trade, Section 1 of the Sherman Act. Now, we can debate, and we had a debate a couple weeks ago at the University of Pennsylvania, and you can see it on the internet. The ABMS did not show up to the debate. But there were a few people who did show up on the other side, and it was a lively debate with many medical students in attendance. And one can debate whether recertification, the people who promote it will say, well, maybe this helps people become better doctors. They can argue that. There have been no good studies that show that it does help make someone a better doctor. There just aren't, you know, and you can look at the literature and those studies are not out there. I know the people who promote the recertification are desperately trying to fund studies to try to show that this results in somehow better care. But that can be a debated issue. But it's undebatable, it's indisputed that this recertification does reduce the availability of physician services for patients. There's no debate about that. This takes time of physicians away from their patients. This eliminates some physicians from the market. This results in physicians being excluded from hospital staffs. There's 10 or 20% of physicians flunk these tests, this recertification, and that makes it difficult for them to continue to treat patients. So it's indisputable that this recertification makes the shortage of physicians worse. It reduces the access by patients to physicians, and that's an antitrust violation. And that's what our lawsuit is. So that's the first claim in our lawsuit. And the second claim is we're complaining about how the ABMS is out there making statements on their website, inviting the public to look and see who is recertified and who isn't. And they are implying that there is a difference in quality between the physicians who are recertified and the physicians who aren't. And we object to that because there is no proof that there's a difference in quality between those two physicians, and we don't think there is any difference in quality between the physicians who've recertified and the physicians who have not. To have the ABMS out there pretending that recertification is some measure of quality, that's a false and misleading statement that we object to. And so we're asking the court to order the ABMS to stop saying that. And we're asking them to stop restraining trade. And we're asking the court to declare all these agreements between the ABMS and these 24 specialty groups, which they have agreements among themselves, to declare those agreements null and void. So we're going right at them with this lawsuit here. I got a copy We've posted it on the website. We welcome your support and your feedback on it. We've raised some money to fund it. And the other side, the ABMS, is already lawyered up in defense of this thing. We sued in New Jersey. They've hired a law firm in New Jersey. They've been in touch with me. They've put a couple attorneys on it. But we welcome that. We like being the underdog, so to speak. You know, they can throw all the attorneys on it they want. But the nice thing about the court of law is it's the truth that will come out. And the legal standards, the legal requirements are going to govern the outcome of this case. Let me move on now and speak briefly about another case we've got ongoing, which is AAPS versus Sebelius, or more commonly known as AAPS versus Obamacare. And while Wayne said that Obamacare is here to stay, I'm not so sure about that. I'm not so sure it is here to stay. We have this lawsuit pending, and the claim in our lawsuit is something that has not been decided yet by the U.S. Supreme Court. As you know, last summer the U.S. Supreme Court issued a ruling that the Patient Protection and Affordable Care Act, which is a formal name for the law, could not be justified by the Commerce Clause. It does exceed the commerce power as provided by the Constitution. However, then Chief Justice Roberts, in his wisdom, found another way to uphold the law, and he upheld it as a tax. And he said, I'm upholding Obamacare as a tax, not under the Commerce Clause. I agree, it cannot be justified under the Commerce Clause, but I will uphold it as a tax. Well, that's where it's at. But there's another provision of the Constitution that Harry Reid and Nancy Pelosi didn't pay much attention to. Not sure that they carry a pocket copy of the Constitution the way that many of us do. And if they had, or if they had consulted with the Tea Party groups and given a little thought to what you have to do in the Constitution if you're going to enact a tax, if you look at Article 1, Section 7 of the U.S. Constitution, it says, all bills for raising revenue shall originate in the House of Representatives. All bills for raising revenue shall originate in the House of Representatives. Well, Chief Justice Roberts has said this is a tax. It certainly raises revenue. And what Harry Reid did was he took a tax bill from the House of Representatives, but the tax bill he used to gut and amend in the Senate, which is the way legislatures sometimes work. They'll take a House bill that says one thing, and then they'll strip everything out and put something else in it in the Senate, pass in the Senate, send it back to the House. The tax bill that Harry Reid picked to strip out and put Obamacare in was a tax credit. It was a tax credit for veterans in buying their homes. It was not a revenue-raising bill. The tax bill that they used for Obamacare, that originated in the House, did not raise revenue. And Article 1, Section 7 clearly says that if it's a bill for raising revenue that you're going to pass, all bills for raising revenue shall originate in the House of Representatives. He did not use a revenue-raising bill. And our lawsuit raises that claim that, okay, it's a tax now, but it's not a constitutional tax because it did not use a revenue-raising bill that originated in the House of Representatives. Now, some may think, well, what difference does it make? I mean, what difference does it make? Actually, the founders spent a lot of time working on this provision. And historians of the Constitution, of which I know we have so few in Congress and the White House, but historians who look at what the founders intended by these provisions say this was a very important clause. They wanted to protect against excessive taxation by making sure it was the House that somebody in the House who gets elected every 2 years, has to face his constituents every 2 years, stands up and initiates the revenue-raising thing so that he then can be defeated by his people, or really, more realistically, he wouldn't do it in the first place because he's more accountable to the people. And he's not going to raise revenue in the House. And if we force the revenue-raising bills to start in the House, then we will get fewer tax bills that way that become law. And they debated this, and some founders were opposed to this provision. But the provision was put in to safeguard against exactly what they did with Obamacare, which is have the bill start in the Senate where the senators are not as responsive to their constituents. They're elected every 6 years, and they could get away with it rather than having the thing originate in the House as the Constitution requires. This has never been decided by the U.S. Supreme Court. And it will have to be decided with respect to Obamacare, and our case is pushing it up there so that the Supreme Court will pass judgment on Obamacare a second time. And in addition to this argument about the origination clause, there are other reasons to think that maybe the Supreme Court, if they reviewed this a second time, maybe they would come to a different conclusion. We have Democrats now who are openly saying that Obamacare has become a train wreck. Sebelius is not implementing it the way she was supposed to be. States were supposed to adopt these health insurance exchanges, but most states said no to that. Many states rejected the Medicaid expansion. This is dividing the country. This is becoming a huge mess. And the Supreme Court may welcome another opportunity to look at this and say, you know what, maybe this isn't such a great idea after all. What we've got is a huge problem that's getting worse. Nobody knows what's going to happen. Different parts of the country are going in different directions on it. People are getting very angry about it. A significant percentage of Americans don't even think it's a law anymore. There are polls that show that there's something like 30% of Americans think it was repealed, and it's not even the law. And if to get another case up there for the Supreme Court to look at it, they may say, it was 5-4, we affirmed it last time. You know what, we did that in an election year. We didn't want to overstep our power. There was a presidential election a few months later. We wanted to let the people, sort this out. But now, nobody is cooperating, the thing's broken. Now we feel a little differently about it, we're gonna strike this thing down. In other big high-profile cases, the Supreme Court has reversed itself within a period of just 2 or 3 years. One of the famous examples is when the Supreme Court held just prior to World War II that a member of Jehovah's Witnesses could be required to say Pledge of Allegiance to the flag, even though that's against the religion of Jehovah's Witnesses to salute a flag like that. And the government could force them to do that. And just a few years later, the identical case came up and the court completely reversed itself and said, no, we're not going to make somebody do that if it's against their conscience. So the Supreme Court does reverse itself, but they need a case to do it. Someone needs to bring a case before them for them to do it. The Supreme Court cannot rule just in a vacuum. So AAPS is pushing this case up there, and we hope that there are more cases like it that come along. The states, I don't know, the states have kind of given up. It's unfortunate. States have not continued to bring more challenges to Obamacare. So Kathleen Sebelius has complained how there are still some challenges that are continuing, and that she has complained about that because I guess she's using it as an excuse maybe for why she hasn't implemented it the way she's supposed to be. But it would be good if some states got into this too, and we could bring an action here in Ohio. If there are any individuals here in this room who want to bring an action in Ohio, this is a venue we have not challenged Obamacare here. We could bring a challenge here to get that going and moving up the court system. So that's where we are on Obamacare. I guess I'll just close mentioning that we don't have any big lawsuits against hospitals yet. But that may be the next frontier, in addition to our lawsuit against the medical board, state medical board, against Obamacare, against the ABMS. I think we may need some sort of lawsuit against hospitals, because hospitals have not received that level of accountability and check and balance on their power that we have brought to the Texas Medical Board. Somebody needs to stand up to hospitals. As it is right now, they're doing whatever they want, and they have not lost anything in court, or by and large, or in the political arena. They're getting very powerful in the political arena too, to the point where in Texas they're pushing through legislation to give hospitals the right to detain people for 4 hours without any approval by local law enforcement. This is how one-sided it's getting in hospitals, where they can detain patients on their own and prevent patients from leaving, and use that as a way to intimidate patients. And of course, they're excluding independent physicians from their staff. We know about that. We need a strategy, and we'll be talking about this tomorrow at our board meeting, what we can do to check the growing power of hospitals and make sure there's an appropriate balance and accountability for what they're doing. Okay, well, thank you for all your support.